Swayam Prabha. Digital India. Educated India.
Welcome to the course on medical law. This lecture will be about do's and don'ts for legal practitioners. The concepts covered in this lecture are professional ethics of lawyers, consequences of professional misconduct, duties of lawyers, do's and don'ts for legal practitioners. The keywords of this lecture are legal representation, medical malpractice, patient confidentiality, healthcare fraud and regulatory compliance. In healthcare industry, lawyers have a major role to play. The lawyers will majorly focus on the legal rights and of patients and medical practitioners. Such lawyers are usually referred to as medical attorneys or medical lawyers. So, their main role will be to handle the legal matters related to the healthcare industry. So, they will advise clients on various legal matters. So, their clients will be either the patients who are taking some services from the healthcare industry or the providers of service in the healthcare industry like various clinics, hospitals or the doctors themselves. They will represent their clients in the court. So, if there is a legal dispute either between the clients, that is the patients, or the professionals in the healthcare industry, such disputes will be handled by the lawyers. So, they will be appearing on behalf of their clients in the court. They will provide advice to medical professionals, hospitals and other establishments. They will make sure that the negligent healthcare provider will face the appropriate criminal charges. They will assist the hospitals in running their business. So, the lawyers also have a significant role to play in the healthcare industry by handling all the legal matters related to the industry. So, the professional ethics is an important aspect with regard to legal profession. Professional ethics could be defined as a collection of written or unwritten principles that govern the behavior of advocates while they are practicing in the court or in their relationship with the client. So, they have to take care of several ethical principles while they deal with the client's matters, either during the discussion with the client or when they are practicing on behalf of their client in the court. Consequently, the ethics of legal profession comprise of the collection of practices and standards that govern the professional conduct of bar members. Upon becoming a lawyer, an individual's interaction with others are generally governed by the general principles of law. Nevertheless, advocates are bound by bar's exceptional principles of professional ethics. So, advocates are bound by the written and unwritten principles of professional ethics. So, they have to maintain the decorum and decency in their legal profession. Maintaining an amicable relationship between the bench and the bar and preserving the dignity of legal professionalism are the principal goals of ethics of legal profession. One of the principal legislations that deals with professional ethics of lawyers is the Advocates Act 1961. The Advocates Act 1961 was enacted based on the recommendations of All India Bar Committee as well as the Law Commission. The Bar Council of India is established under Section 4 of the Advocates Act. The principal duty of the Bar Council of India is to maintain the professional ethics among the legal practitioners. So, according to the provision Section 1 Clause B, it is the duty of the Bar Council to establish guidelines pertaining to professional behavior and etiquette expected of advocates. Section 49(1)(c) confers the Bar Council of India the authority to establish regulations pertaining to delineation of the expected level of professional conduct to be adhered by the advocates. So, advocates throughout their profession has to maintain the decency and ethical standards as prescribed by the Bar Council of India. So, they are expected to maintain the highest level of discipline in their relationship with their clients as well as during their arguments in the court of law. They have duties towards the courts. The duties of advocates to courts encompass the obligation to keep demeanor characterized by respect and dignity towards the judicial system. It is imperative to refrain from exerting any unlawful or inappropriate methods to influence the decision making process of the courts. So, the advocates must strive to exert their utmost effort in order to prevent their customer from engaging in unfair activities. So, they have to maintain the highest level of discipline while they are in the court. They have to take adequate measures to protect the interest of their clients, but at the same time they should not engage in any inappropriate methods to influence the decision making by the court. In order to attend court proceedings, they are bound to follow the established dress code and present oneself in a manner which is considered appropriate and respectable for a practicing advocate. The wearing of bands and gowns is typically reserved for courtrooms and ceremonial events. So, when they interact with their clients or while they are in their office, they can maintain the normal dress code. But while they are in the court, they are to follow the prescribed dress code. The advocates are prohibited from making any plea in any case in which they have a personal stake. So, this is another important matter. So, in case if the advocate is having any personal stake in the matter, then they are completely prohibited from making any plea in such cases. So, if the client is having any personal relationship or business relationship with the doctor or the hospital or the clinic in the healthcare industry, then they cannot take up that matter as an advocate. Similarly, if they are having any personal relationship with the client which is a patient, in such cases also they are completely barred from making any plea in such cases. If an advocate has a position on the executive committee of an organization or a company, so that means if the advocate has some role in the management of the business of the healthcare industry, then they are completely prohibited from participating in any judicial proceeding or appearing before any other authority to advocate the interest of the said organization. The advocate also have specific duties to their clients. The responsibilities of an advocate toward their client include obligation to refrain from withdrawing from acts or engagements without justifiable cause. It is imperative to refrain from accepting or participating in legal matter if there is reasonable belief that one may serve as a witness. So, the advocate also have direct responsibilities towards their client. They are in a fiduciary relationship with the clients. In case advocate is expecting that he may have to serve as a witness in the dispute, in such cases he has to refrain from participating as a legal counsel. In order to ensure transparency and integrity, it is essential for the advocate to fully disclose any affiliations or vested interest they may have with the relevant parties before they start any engagement. So, if the advocate is having any direct relationship with any client or the opposite party, then they have to completely disclose all their interest before they take up the matter. They are already barred from taking cases in which they have any personal interest. But even in case there is no direct personal interest, they have to disclose if there is some matter which will affect their decision making while appearing on behalf of the client. The lawyers must advocate for the interest of their client through ethical methods. So, lawyers are expected to take all efforts necessary to ensure protection of the interest of their client, but at the same time they are expected to maintain highest level of ethical standards. In order to provide a fair and unbiased assessment, it is imperative to refrain from exerting undue influence on any matter, material or evidence that may potentially establish the innocence of the accused. So, they also have to ensure that they will refrain from exerting any undue influence on any material or evidence that may potentially establish the innocence of the accused. So, they have to be fair and unbiased in their assessment about the guilt of the accused. They have to take earnest care to protect the interest of the accused on whose behalf they are appearing, but at the same time they have to maintain fair and unbiased stance in the matter. The attorney is obligated to maintain confidentiality and refrain from disclosing any messages or discussions made by their client to them. So, they have to maintain confidentiality with all the communications they had with their client. So, communications may be oral communications that happened during the advocate and the client meeting, and it can also be the materials which were provided by the client to the advocate. The advocate must not intend to impose fees for their services based on the outcome of situation being addressed. So, the fees of the advocate should not be based on the outcome. They have to tell the fees well in advance, and it should not be based on the positive or negative outcome of the dispute. The fees payable to the professional by their client is not adjusted against professional's liability to the client. So, the fees has to be kept separately from any damages that the client may receive after the decision is given by the court. In order to maintain accurate financial records of funds received from the clients and to furnish clients with copies of statement, it is necessary to adjust the charge in the event of proceeding being cancelled. So, advocate also have to maintain accurate financial records with regard to all their transactions with the clients. The individuals in question is unable to execute payments on behalf of clients or provide financial assistance for legal actions. So, advocates cannot give any financial assistance for legal action, or they cannot make or execute any payment on behalf of their client. Advocates are prohibited from doing all these actions. If an individual has provided advice to a political party on initiation of a legal proceeding, they are precluded from representing the opposing party in relation to the same case. So, in a case an advocate has appeared or provided advice to a particular political party, then in such cases they are prohibited from representing the opposing party in the same legal dispute. The consequences for professional misconduct by an advocate is provided under section 35 of the Advocates Act 1961. So, Advocate Act 1961 is the legislation that deals with the conduct and professional matters of advocates. According to section 35 of the Advocates Act, in the event that an advocate is found to have engaged in professional misconduct, the matter will be directed to a disciplinary committee. The committee will then schedule a hearing and serve a notice to the advocate involved. The disciplinary committee of the State Bar Council will proceed to hear the arguments presented by both the parties. So, matters or disputes involving the professional misconduct of an advocate is dealt under section 35 of the Advocates Act 1961. So, if any person has any complaint regarding the professional misconduct carried out by an advocate, they can give a complaint to the State Bar Council. On receiving the complaint, the Bar Council will hand over the matter to a disciplinary committee constituted under the Bar Council rules. The disciplinary committee is empowered to hear the arguments presented by both the parties and take a decision in the matter. The disciplinary committee can either dismiss the complaint if they feel that the complaint or the matters which are averred in the complaint is not correct. In case they find that the advocate has engaged in a behavior which could be considered as professional misconduct, they can either reprimand the advocate, or they can suspend the advocate from practice for a temporary period, or they can direct for removal of the name of the advocate from the state rolls of advocates. So, the disciplinary committee can recommend an action based on the nature of professional misconduct and its degree. The do's and don'ts of lawyers, which is going to be dealt in this lecture, is segmented under 4 categories: the duties of advocates with regard to patients, the duties of advocates with regard to doctors, their duties with regard to hospitals, and their duties with regard to the government. First, we will start with duties of lawyers with respect to patients. Their preliminary duty with regard to the patient is providing advice on all legal matters. Medical lawyers offer their clients guidance and advice on a variety of medical related issues, which will include medical malpractice, insurance dispute, and other healthcare regulations. According to section 29 of the Advocates Act, advocates are primarily recognized group of individuals who possess the eligibility to offer legal advice. So, they are professionally trained to give legal advice to their clients. So, their primary responsibility is to provide accurate advice to their clients, which can include patients, professionals, and even establishments in the healthcare industry. They will also do legal representation on behalf of their clients. Medical lawyers argue on behalf of their clients before the courts and tribunals. Additionally, they might bargain settlements on behalf of their clients. So, they can also engage in settlement of disputes between the parties on behalf of their clients. They will also draft legal documents which will include contracts, pleadings, and motion, and then make sure they abide by all relevant rules and laws. So, all the documents including contracts, pleading and motions all has to be in compliance with all the rules and regulations applicable to the scenario. So, medical lawyers will be professionally competent to handle such legal documents and draft them. They will also interpret the medical records and other matters. Medical attorneys research and analyze medical records and other pertinent documents in order to build strong cases for their clients. They also inquire the claims made and gather evidences in support of their client and speak to their witnesses. So, medical attorneys are professionally trained to handle various kinds of documents and interpret them. They should also have some scientific knowledge about the medical records in order to analyze them and build strong cases for their clients. They will also negotiate on behalf of their clients. So, they will settle cases without going to trial, and they will also bargain on behalf of their clients. They have to keep up along with the latest developments in law. They will provide their clients with the best legal representation possible. Medical attorneys stay up to date about the developments in medical law and healthcare legislations. The attorneys also have direct responsibility towards doctors. In case of medical malpractice, lawyers have a very important role. Medical malpractice is a legal claim that the healthcare provider violated the standard of care, causing harm to the patient. Medical lawyers represent the physicians in malpractice lawsuits. In medical malpractice litigation, medical lawyers can help physicians combat claims of carelessness or other forms of professional misconduct. So, in case of medical malpractice, the lawyers will have to advise their clients and appear on behalf of them. So, in case the advocate is appearing on behalf of a patient, then he will have to analyze all the medical records and find out evidences that will be supportive of the arguments for his client. And if the matter is taken to the court, then the medical attorney has to appear on behalf of his client. In case the lawyer is appearing on behalf of the establishment or the hospital or the clinic, then he will have to go through all the documents and find materials which will be supportive of defending the claim of medical malpractice. Representation in disciplinary proceedings. Apart from their traditional role of handling legal disputes and appearing in courts, medical attorneys also have a role in representing their clients before various medical boards and other regulatory bodies. So, as they are specifically trained to handle matters with regard to a particular type of industry, they will appear before medical boards or other regulatory bodies and protect the licenses and goodwill and reputation of their clients. They will also engage in negotiation of contracts and agreements. To protect the rights and interest, medical attorneys can assist physicians in negotiating agreements with hospitals, insurance companies and healthcare providers. So, healthcare industry involves various contracts and agreements between various stakeholders. So, the patients will be having some kind of contractual relationship with the doctors or the clinics or hospitals, and within the hospital establishment itself there will be several contracts between various stakeholders. So, all these are legal documents which can be drafted only with the expertise of a trained professional. So, medical attorneys have the role of negotiating these contracts and concluding agreements. Maintaining patient confidentiality is a very important duty with regard to every lawyer. Medical attorneys can provide guidance to physicians on maintaining patient confidentiality and other privacy laws. So, they have to maintain 100% confidentiality with regard to oral communications as well as materials which were transacted between the client and the advocate. In Kamarjit Singh versus State, the Supreme Court decision in 2000, the Supreme Court decided that the right to information does not encompass the ability to request the disclosure of attorney-client professional communications and documents. So, attorney-client professional communications and documents are coming within the privilege of advocates. So, they cannot be forced to disclose any information which was communicated by their client or any document which was given to them by their clients. Supreme Court has upheld this right as a very important aspect with regard to legal profession. So, there is another very interesting decision in Kalikumar Pal versus Rajkumar Pal, which was in 1931 by the Kolkata High Court. It decided that the attorney-client privilege will persist even after the termination of employment. So, even after the attorney-client relationship ends, the attorneys are responsible of maintaining confidentiality with regard to any communication that they came across during their relationship with the client. So, all the oral communications and any other document which was given by the client has to be maintained with 100% confidentiality by the advocates. So, even after their relationship with the client ends, they cannot disclose this information to anyone else. The prohibition of disclosure will also apply to individuals serving as interpreters, clerks or assistant to attorney. So, the privilege will also apply to any person who is working in the advocate's office. Advice on healthcare reform is another important duty of medical practitioners. Medical lawyers shall keep abreast of the changes in healthcare regulation and legislations. They can counsel physicians on how these developments might affect their practices. They also have a responsibility with regard to healthcare fraud. Medical lawyers represent healthcare providers in investigations and enforcement actions involving healthcare fraud and abuse. They also have duties with regard to pharmaceutical and medical device liability. So, this is another interesting aspect with regard to medical attorney practice. In cases involving the safety and effectiveness of prescription medications and medical devices. The medical lawyers represent both the plaintiff and the defendants. So, apart from the traditional cases like medical malpractice or medical negligence, now medical attorneys are also appearing in cases involving pharmaceutical and medical device liabilities. The lawyers also have duties with respect to hospitals. Guidance on healthcare regulatory compliance is a booming profession in India. Medical lawyers are knowledgeable about the intricate laws that govern the healthcare industry and help the hospitals and physicians comply with them. The hospitals, physicians and other stakeholders in the healthcare industry have to comply with various regulatory laws. Medical lawyers will help them in ensuring compliance with these regulatory requirements. These healthcare regulatory requirements are laws in place to ensure that hospital facilities are built after a thorough registration process and they are safe for public to use, and that the bare minimum infrastructure for the type and volume of workload anticipated, and they are subject to periodic inspections to ensure compliance. So, all these regulatory compliance will be taken care by medical attorneys. They will also draft, review and negotiate contracts involving healthcare providers, payers and suppliers, such as managed care contracts, hospital physician contracts and group purchasing agreements. So, there are several contracts which are entered between various stakeholders in the healthcare industry. Medical lawyers will be the ones who will draft, review and negotiate such contracts. They will also study medical law, healthcare legislations and pertinent case law to develop strong legal arguments for their clients. Medical lawyers assist the hospitals in designing and administering employee benefit plans such as health and welfare benefits, maternity benefits and retirement plans. When it comes to employment, intellectual property and tax laws that are relevant to healthcare industry, it is the medical lawyers who can provide guidance to physicians. So, apart from the normal traditional legislations that apply to healthcare industry, there are also intellectual property and tax legislations which will apply to various stakeholders in the healthcare industry like patients, practitioners and professionals in the industry. It will be the medical lawyers who will guide the various stakeholders with regard to these matters. Lawyers also have direct responsibility towards government. They will assist the government in various healthcare programs. Lawyers specialized in healthcare and medical law can work closely with governments also. They also help the government by reporting true state of affairs with regard to healthcare infrastructure. They assist the government in developing various policies. Healthcare attorneys and medical lawyers help the government to formulate laws and policies keeping in mind the needs of healthcare industry. To conclude, the primary responsibility of an advocate is to protect the interest of their clients. So, they will be responsible for a variety of tasks that help the client to win his claims. Generally speaking, lawyers are expected to have both the soft skills that are useful for maintaining the required professional behavior in the courts and also strong legal and technical foundation which will help them to protect the interest of their clients. A lawyer can provide advice on the best course of action to take and help the client understand their legal rights and options. This might also help them navigate the complex legal and medical concerns and defend the clients in the court. The references of this lecture can be seen here. Thank you very much for listening to the lecture. I hope you are enjoying the course.